who wants to introduce the show?
I can introduce the show.
Okay, do it.
All right, ready, set, go. Hi, everyone. Welcome to Everything We Know About the American Heartland. This episode is Everything We Know About the American Heartland as it relates to Neil Gorsuch. As many of you may have heard, Neil Gorsuch is President Trump's, I'm having trouble saying those words, but I'll say it, President Trump's nominee to the United States Supreme Court. So we thought we would get together, myself, Ruchit, Tom, and AJ, and talk about Neil Gorsuch. And what do you know about Neil Gorsuch?
Earlier in the week, I did not know that he existed, and now here I am on Saturday, fully aware of his existence.
Tom, what do you know about Neil Gorsuch?
Pretty much the same. Yeah, I think we should probably structure this conversation about some of the cases that we've read and some of the writing that we've read, because one thing that I have noticed consistently in reading his writing is that he is an incredibly talented writer. He's crystal clear when he writes.
I find him to be Scalia without the flair.
I find him to be... I agree on that in the sense that Scalia, but I think he does have flair. I think he's just Scalia but polite. And to me, that raises the question of, is he Scalia but polite because he's 49 years old and he hasn't entered that phase in his life where he's just angry at everyone? Or is he Scalia and polite and we should just continue and expect him to be polite? I don't know. Have you guys read anything of his that has that sort of caustic tone that Scalia sometimes has?
I mean, I think Western Wireless versus the Colorado PUC is clearly a caustic tone, just without any of the fun words, right? He doesn't call anything applesauce, but I think he's just as caustic as Scalia ever was.
So let's talk about that, AJ. I mean, you're a public utility lawyer. You're probably the only public utility lawyer that podcasts, I would say. And so maybe you can tell us a little bit about this Western Wireless versus Colorado PUC. And what's this case about? Why does it matter? Why should we care what Neil Gorsuch wrote here? But maybe just start about what's this case about.
So Western Wireless was a wireless telephone provider, basically a cell phone provider. And there is a system of subsidies administered by the federal government called the Federal Universal Service Fund. And what the statute says is providers are eligible to receive subsidies, and states hand out the designations. And so providers go to the state where you're doing business and say, I'd like to be made an eligible telecommunications carrier, eligible to receive these subsidies. And the states, here are some guidelines for granting approvals, but feel free to add additional requirements on the providers. The one thing is that some provider services are split up between interstate and intrastate components. So intrastate components are things you would say, in this case, happen entirely inside Colorado, and interstate components of the service are things that affect the entire country. And what Colorado did is they imposed some requirements on Western Wireless's intrastate services, and Western Wireless said, well, you have to understand, we bundle all of our services under one rate, and so when you put requirements on our intrastate services, you're putting requirements on this bundle that includes interstate services, and you're burdening our ability to provide interstate services in violation of the Act.
Without going into too much on the intricacies of telecom law, but why do we have subsidies? Why do we have a situation where the federal government regulates some of this communications, but then the state government regulates other parts of this communications? And I'm asking this for the folks that are not lawyers, and especially not telecom lawyers.
Basically, almost the entire telecommunications regulation scheme has this idea that states should be responsible for activities that are within their state, that are intrastate activities, and that the federal government will regulate activities that are affect interstate commerce, the sort of thing that the Commerce Clause was designed to say, well, Congress shall make regular the commerce amongst the states.
So how does Neil Gorsuch, Judge Gorsuch, get involved here?
Well, so what the majority said is they go through this this long explanation of why what the Colorado PUC did was okay, and it's sort of not important what the majority's reasoning is. And this is at the circuit court level, the 10th Circuit, where Gorsuch is presently a judge. And there's this line in the majority opinion that struck out to me, and it said, I'm quoting now, "Our decision is aimed solely at the question presented, whether the Telecommunications Act permits a state to impose ETC conditions not related to regulation of rates or market entry that affect the interstate components of a mobile carrier that bundles its interstate and intrastate service." And Gorsuch dissented from this opinion.
And what's his, why did he dissent?
Well, he thinks that the opinion overreached when it should have been more limited. He said that there's this theory that's advanced by the majority that was never presented by the parties in the case, and it would be overreaching for the court to start making up arguments on behalf of one party or the other and exerting its jurisdiction over those questions. And so he says, and this is quoting from Gorsuch's dissent, "The majority approaches this question by pursuing the broad thesis that state commissions are free to regulate any non-rate terms and conditions of interstate service provided by mobile service eligible telecommunications carriers." And to me, that sentence is just blatantly false, right? I mean, based on the sentence we read before, where the majority had said that their decision is aimed solely at the question of whether you can address the interstate components of a mobile carrier that bundles its interstate and intrastate services. I think Gorsuch's statement is both reductive and aside from the point. I think there's a little bit more to what's going on here than what Gorsuch has actually written.
And so what do you think, kind of building upon that, what do you think is sort of going on here? And maybe bring this back a little bit in terms of the high level of what can we actually take away from Gorsuch deciding to dissent in this situation? And let me expound upon that a little bit, which is that you have a situation here which is kind of common if you think about sort of federal and state jurisprudence, right? You have a federal law, you have a corporate entity, and then you have a state regulator. So you have a federal regulator, a state regulator, and some corporate entity. And what happens a lot of the times is the corporate entity wants favorable regulation. And so sometimes they can get that from the state regulator, sometimes they can get that from the federal regulator, but they're playing these two off of each other. And it's a judge's job probably to try and figure out what the right resolution is there. But what is Gorsuch trying to do, and what is he specifically ruling here?
Well, I think a theme that is going to come up in the confirmation process is that was similar to the criticisms levied against Samuel Alito, that he sort of never fails to rule in favor of corporations, and he never found a corporation that he liked less than the government or whatever. That I think Gorsuch's opinion here is aimed at helping Western Wireless receive federal subsidies under the easiest terms possible, in a way that reduces Colorado's regulatory authority. It sort of something to keep in mind is that this case was happening around 2007, and the federal law sets out minimum requirements for designation and said the states can impose additional requirements. And I think Gorsuch sort of understands that the George W. Bush FCC isn't really interested in imposing particularly many more requirements on these companies. So what he's doing is creating a pro-business environment by restricting the state's authority to regulate Western wireless services when Colorado has the authority under federal law to hand out or not to hand out the designation to receive these subsidies. And I think really at the bottom of what it's getting at is you've sort of mirrored Scalia's sort of toxic and caustic approach to addressing your colleagues with basically trying his best to reduce the state's authority to regulate the business services that are provided within the state's boundaries.
Let me ask you guys something. Is there an example such as the Colorado PUC case where Gorsuch is actually in the majority?
Where he is maybe more, how would you say, in favor of state regulation and not as much in favor of sort of corporate interests. And so that is a clean energy case. Yeah. But go ahead, Tom.
And I guess before we jump too deeply into that, the reason I ask is that his dissenting opinion in the Colorado PUC case is useful only insofar as it may give us hints at how he might act on the Supreme Court, but it's not really the law of the land. He's basically screaming into the wind when he dissents, as most dissenters are at times. So if there's an example of what he does with power when he's in the majority, I think that might be better a better explanation of what he might actually do in the role of a Supreme Court justice.
Well, I think the only area that I can think of is sort of antitrust cases. So yesterday I was reading one of his antitrust opinions, which was Novell v. Microsoft, I think. And that was another example. It was, I think, in many ways classic Gorsuch in that it was extremely well written. If there's anyone that wants to understand antitrust law, they could totally read that.
Richard, can you just give us the basics of the Microsoft case?
Yeah, so it's actually a really interesting case. So what happened is, in the 90s, Microsoft had been sued by the Justice Department for engaging in anti-competitive behavior, essentially using their monopoly in Windows to the detriment of other competitors in their marketplace. So nowadays we hear about APIs quite a bit. But Tom, did you want to say something? Sorry. Okay.
Yeah.
I saw the hay, dude. No. I saw the hay, and I had to let Tom intervene.
Just to give everyone some background, we're using cast at trycat.st to connect this call and record the podcast, and there's a little button you can click to raise your hand. And Tom, your hand is very clearly raised right now.
Yeah, dude.
You should unraise your hand.
Unraise
You've been saying hey for like minutes now, Tom. So AJ and I have tried to defer to you. But so here, let me go back to Microsoft v. Novell. So Novell was the developer of WordPerfect. And so if you are over the age of 26, you may remember what WordPerfect is. If you're over the age of 35, you definitely know what WordPerfect is. So Novell had developed all of these Microsoft Word competitors, and they were actually really successful. And in Windows 3.0, they were really successful. And then come Windows 95, Microsoft had started developing Microsoft Word, Microsoft Excel, and they had to make a decision about whether what they were going to do as it related to competitor products like WordPerfect. And so they made the decision at first to allow API access for WordPerfect. Now, a lot of tech folks that may be listening here know what an API is. And for the folks that aren't tech, I guess you could say, an API is just the ability to write on top of a different operating system, to program on top of it, to make sure that the programs sort of work with each other. And so Microsoft had allowed API access for competitors like Novell, who was making WordPerfect. And 6 months before they released Windows 95, they just changed their mind, right? They said, you know what, we're not allowing access anymore.
Imagine we had a sponsor break here and everyone were very anxious to give us tons of money for advertisements. So this is the second half of everything we know about the American heartland in our episode about Neil Gorsuch. And Ruchit was just finishing explaining the Microsoft Novell antitrust case. And I think what we're getting at is the big takeaway is that it's probably bad. Like Microsoft is probably bad. And also the judiciary system.
Yeah, probably.
Probably, right?
Yeah, probably. I think the interesting thing about that antitrust opinion, which is worth sort of reiterating, which I wasn't super clear on before, is that what Gorsuch is doing is he is taking the scope of antitrust law, which is designed to protect consumers and to protect competition, and he is narrowing that scope. And that's something that I think you see in a lot of his decisions, and you see a lot in almost a John Roberts approach to being a Supreme Court justice or appellate court justice, is you just slowly chip away at that.
How is he narrowing the scope?
So what he's doing is he's saying that when a corporation refuses to deal with its competitors, and in this specific context, so think about technology, right, for a moment here. And think about the app ecosystem. The Microsoft case deals with the app ecosystem like 20 years ago, which is Windows, all right? Now apply that to Apple, apply that to Facebook, apply that to other companies that have the potential of having something like a monopoly. And what he's saying is that their refusal to deal with their competitors by letting other people onto the ecosystem, especially their competitors onto the ecosystem, is not anti-competitive. And to me, it smacks... Go ahead.
What was his basis for saying that? Like, what reasons did he have? What was his logic?
His logic is that if you as the judiciary try and regulate under what conditions a company has to provide access to its competitors, what you're effectively doing is you're potentially stunting innovation and you're potentially making a lot of things subject to judicial review that shouldn't be. And he's saying that you are taking the focus away from whether competitors are harmed, or not competitors, rather consumers are harmed in an immediate and narrow sense. I think in a lot of ways, he's very cleverly saying that, listen, monopolies don't really exist, but if they do, it's going to need to be really abundantly, blatantly clear before I find that they're doing anything that is anti-competitive.
Let me ask you something. From that Microsoft Novell decision, can we learn anything about how Justice Gorsuch on the Supreme Court would handle a net neutrality issue that would come up before him?
Yeah, I think we absolutely can. I think we can find that he doesn't. So there's a case called the Aspen Highlands case, okay, which the Supreme Court decided. I don't know. This is a 20-year-old case, but the fact pattern is such. There was a company that owned 3 of the 4 mountains, ski mountains, effectively in Aspen. And they created a bundle pass. And they said, listen, you can have access to all 3 of our mountains, 3 of the 4, because some other company owns the 4th, right? And you can have it for a very, very low price. And they said the 4th mountain said, listen, we just want to buy your 3 mountain pass at retail value. That's all we're trying to do. And we're going to now bundle your 3 mountain pass with our 4th mountain pass and resell it for some other amount of money. And what the Aspen company did, the mountain company did that owned 3 of the mountains, they refused to deal. They refused to sell their 3 mountain pass to the 4th mountain company. And so I think and what the Supreme Court found there is that refusal to deal was an antitrust violation. And the reason it was an antitrust violation is because the company that owned the 3 mountains was basically trying to force the company with the 4th mountain completely out of business by underselling the shit out of their 3 mountain package and refusing to sell that 3 mountain package to the 4th mountain company so that they could then resell it. And so what that did is it basically tried to drive the 4th company out of business. So the Supreme Court there was saying, hey, a refusal to deal with your competitors can actually be an antitrust violation. What Gorsuch did in his Novell v. Microsoft opinion was chip away at that idea. And so let's take it to net neutrality. Tom, do you want to say anything here? Am I being clear, I guess?
Yeah. Well, I guess just in general, net neutrality is the idea that a provider of a network service can't discriminate against the folks using the network service. I guess is the most basic way to say it. AJ or Ruchit, you want to add anything to that?
I think also the idea of net neutrality is that the carriers that are providing access to the internet are not supposed to make their services any different depending on the origin of where the content is coming from or the nature of the content itself. So the idea when a provider says, oh, we're going to say that the New York Times has faster access to the internet than the New York Post, or or for another example, we're going to prioritize video streaming over other types of traffic. The idea is that it gives companies too much control over people's access to information. That, in a lot of countries, access to the internet is considered to be a fundamental right, and that for large corporations to be choosing how people have access to information is sort of inappropriate.
Yeah, what I was going to say is that like it starts with a ski mountain, right? And it's sort of like who cares? Who cares if 3 of the 4 Aspen ski mountains are monopolists, right? Like let's say all 4 of the mountains in Aspen are controlled by one company. Who cares if somebody has to spend a little bit more on skiing Aspen? I mean, they should just go somewhere else, or they should just spend more. It's kind of a rich person's problem anyway, right?
So, Rich,
Yeah.
can you break it down as to exactly how the Novell decision and the ski mountain decision would tell us anything about Gorsuch's views on net neutrality?
Yeah, I can. So the ski mountain decision was a Supreme Court decision that said basically the decision to treat your competitors differently than any other member of the public was an antitrust violation. Okay? So it said, listen, if you are an owner of a ski mountain and you sell the public a pass for $99 for access to 3 mountains, you have to sell access to everyone else at that exact same price. You can't say that, Tom can buy it for $99, but my competitor has to pay $400, or I'm not willing to let my competitor buy that pass at all. Okay? In the Novell case, what you have is a situation where Microsoft is making it difficult for anyone else to write software that's competitive to Microsoft Office. And they're using the power that they have with Microsoft Office or Microsoft Windows to make it harder for anyone else to develop competitors to Microsoft Office. Okay? So let me keep going for a moment into net neutrality. All right? Net neutrality is the principle that you need to treat everyone's content, you can't discriminate based on what the source of the content is. So let's take someone like Time Warner, okay? Time Warner could say, well, we have our own video package and we control access to the internet for, this entire neighborhood or this entire community. And so we're going to purposefully slow down access for Netflix, and we're going to speed up access for our own services. So we're going to discriminate to favor ourselves. Does that make sense?
It does. Yes, it does.
Yeah. So I think if you look at the Supreme Court in the Aspen Mountain case, they would probably find, without being too bold here, they would probably find that if Time Warner decided to violate the concepts of net neutrality, they would potentially be committing an antitrust violation. I think what Gorsuch would say in this situation, just looking at his Novell v. Microsoft decision, is he would say, no, that's not a violation because it's just a refusal to deal with one's competitors, and you can refuse to deal with your competitors whenever you want.
Do you think that is an issue that would have traction in opposing his nomination?
I think someone would have to say it a lot better than I just said it, frankly, to explain why that would be the case. But yes, I think net neutrality is an important concept. There have been a ton of protests whenever, net neutrality issues have been before the FCC or have been before Congress. So yes, I do think that if one can credibly argue that Gorsuch is going to be against net neutrality because of his views on antitrust law, then I think that's something Congress needs to dig into.
So let's talk about something else that Gorsuch has written, not a judicial opinion, but he wrote an article for the National Review in 2005. And in the article, he basically says that the left wing of the country is addicted to lawsuits, that they're addicted to suing the government to achieve policy goals, and that the left has done so in a way that's lost the thread of being able to make their issues more broadly popular in the country, and instead they're sort of usurping the governing authority that has accrued to the Republicans, who at the time had the presidency and both houses of Congress. Do y'all have a takeaway from this article?
Yeah, well, I don't know about takeaways, but I do have a couple of things that I'd like to say about the article. One of the first things that I noticed is that this is a judge who is critiquing the right of litigants to use or access the courthouse. At base, that's what this article is. It is a judge telling litigants that, hey, maybe you shouldn't be going to the courthouse as much as you are. And That's really worrisome to me because I think in the and Ruchit points out that he wasn't a judge at the time, but it would be fair to say that he doesn't abandon his views when he becomes a judge the next year. But what's really worrisome about these types of views when held by a judge is that the courthouse isn't sort of a place where just only a certain elite class of folks can go to. In the American tradition, the courthouse is the great equalizer. It's the place where an individual, a person without power, can go and be heard by a jury of their peers, and no matter whether the individual or corporation or entity on the other side is another individual or a corporation or the biggest corporation or even the United States government, the individuals, the courthouse holds folks accountable. And you know, it's kind of sad to me because, you know, this tradition has brought about, you know, the great lawyers of our time, the defenders of folks who really defended justice, like Clarence Darrow, and
Thurgood
Marshall, yeah,
Ginsburg,
and even in our imaginations, you know, in literature, folks like Atticus Finch. These are people historically that we have admired, and so when Gorsuch in his, you know, article ties those types of folks and just calls them trial lawyers and lumps them in with liberal causes, it really makes me wonder how he thinks about, you know, whether individuals have the right to access the courtroom. The other thing that I would say about this article is the theme of the article is this idea that, you know what, if these liberal causes are using the courthouse to get what they should be getting from the legislature, right? But, you know, not even a few years later, when Citizen Gorsuch becomes Judge Gorsuch, he writes a concurrence in Hobby Lobby v. Sebelius. That's the contraception mandate case where Hobby Lobby and individuals were saying, look, the government can't tell us to allow or pay for insurance plans that provide folks with contraception. And at base, that case is an example of the very thing that Gorsuch is complaining about in this National Review article.
I mean, the thing that it strikes me here, honestly, guys, is that these conservative justices sometimes, they don't believe in public interest litigation. That is when the Sierra Club, a civil rights group, a gay rights group, brings litigation to right or wrong. But they do seem to believe in corporate interest litigation. When Microsoft, you know, brings a case, when a utility company brings a case, when a massive privately held company like Hobby Lobby brings a case. So that's what's really frustrating to me, because if you believe that the system has a certain amount of, the legislative system especially has a certain amount of corruption to it, which sadly I do believe that, what that means is that the courts are the last place where ordinary citizens and public interest groups can go to get justice. And if every time they go, you reduce that to, well, there go those crazy leftists, you know, they just keep trying to get justice through the courthouse. It's sort of like, yeah, that's what courts are. They're dispensers of justice. They're not dispensers of just what does the majority believe, you know, which is what the legislature sometimes is, right? So I don't know. I thought this was where he was, that article that you talked about, Tom, the National Review article, he was more Scalia in that article than we've seen him be as a judge. And I wonder if he's not going to get back to that. You know, if he's not going to get back to being more and more Scalia, which is just sort of caustic and dismissive of people he disagrees with.
I just found the article to be totally tone deaf. Right? Like it sort of seems like government moves back and forth between Democrats and Republicans every so often, and to be writing that right in the middle of a Republican administration, like who's going to sue the government? Like conservatives aren't going to sue the Bush government. You know what I mean, right? Like I just find the article to be totally tone deaf because it's coming out in 2005 when the government is conservative, and who would need access to the courtroom but the left, right? And I think that Gorsuch himself is not so far removed from the 1990s when the government was for the most part run by Democrats, and that it was conservatives who were availing themselves of the courthouse. There are things like in Lopez where they wanted more guns nearer to schools, or things about whether to have expansive background checks for gun purchases. And I think that Gorsuch is not a dumb person. I don't think he's so far removed from a period only 10 years prior where it was conservatives who really needed the sort of access to the courthouse that he was decrying liberals for taking advantage of.
It's always, I mean, over the last 50 or 60 years, who has it been but people with the minority view, right, that are shut out of the legislative process, that are shut out of the executive process, that need the courthouse. And I think that's been a steady trend over the last 20 plus years. Gorsuch is right in the conservative mainstream, if you will. We don't want these things settled in the courthouse as a way of denying people access to justice. That definitely bothers me.
One of the things that I tried to research and look up when I read this article is whether Gorsuch had ever tried a case when he was in private practice. And I couldn't find anything. I don't know if either of you found an example or a citation to where he had actually tried a case.
I hadn't looked into that, but I would be interested to know.
Yeah, I hadn't looked into it either.
I guess the reason I would ask that question is because I think it's, having to actually try a case as a lawyer is it's not an easy task, and it is where the rubber meets the road when it comes to the practice of the law. I think up until that point, up until you're actually trying to persuade a bunch of folks who are ordinary citizens that your side is correct or the other side is wrong, or whatever point that you're trying to persuade, you really don't have a good handle on the practicalities of the law. And I think any person who has tried a case or who can empathize with just trying to convince regular folks of one thing or the other probably wouldn't write an article saying that certain classes of folks shouldn't have access to the courtroom.
Maybe we should talk about what the Democrats should do here with Judge Gorsuch.
Well, I read a really interesting article by Bill Schaer in Politico, and there's some question among Democrats about whether they should filibuster the Gorsuch nomination, and Bill Schaer says that if the operating assumption is that waging a filibuster means losing the filibuster, that is, if your concern is that by engaging in a filibuster here, that the Republican Senate majority will eliminate the filibuster from the rules, he says, if that's what you're worried about, then the filibuster's already lost. Just look at the way the two scenarios play out. This is Bill Schaer. One, you filibuster Gorsuch, you lose the filibuster, Gorsuch is confirmed, and the next nominee is confirmed. Scenario two, you confirm Gorsuch, filibuster the next nominee, lose the filibuster then, and the next nominee is confirmed. The two events are totally the same, basically. So, in my mind, the concerns about the Republicans using so-called nuclear option is sort of beside the point.
Well, I think let me give you the flip side of that argument. As someone who saw what the Republicans did to Merrick Garland, it's really frustrating that this idea that they should be rewarded for their obstructionism, because that's in essence what they're doing. And if you think about it, if they had fulfilled their constitutional duty of advising and consenting, if they had just given him a hearing or a vote, this seat wouldn't be up for grabs. This seat wouldn't be up for Trump's nomination. And so it's really frustrating that they can be obstructionist and get this basically reward for their obstructionism. Now, the flip side of that argument is that two rights or two wrongs don't make a right. this entire system and our respect for institutions is really what has kept the American system alive and well for so long. The idea that we all know that this is a democracy, this is a republic, if we can keep it, right? The idea that it takes hard work, it takes understanding and work of everyone in the system to keep the machine of American democracy moving forward, and it can really collapse. What if we do? Because if we do filibuster, if the Democrats do filibuster, it's scary because it in essence means that there's no party up there who's willing to be the adults in the room.
Yeah, I think they shouldn't filibuster, and I think it's precisely for that reason. I think they should be the adults.
I think they absolutely should filibuster.
I don't know. I think they should be the adults in the room because somebody has to be the adults in the room, and sadly, that you can't take the high road if what you're saying is well, that idiot took the low road. Well, yeah, that's why you have the high road. It's because he took the low road. You know what I mean? So
I think there are 2 points worth saying on that, right? The first is that there is, at least the Republicans have managed to pay very little political consequence for their obstructionism, right? And the operating theory that Democrats should have as the new opposition party is that there is practically no political consequence to obstructionism. Meanwhile, obstructionism can achieve meaningful and palpable policy goals. And so if you're sitting in the legislature and you think that for practically no political cost you can achieve meaningful policy goals, I mean, you'd sort of be unethical not to do it, right? Like, I could for free achieve these things that I believe are for the benefit of the country, but I choose not to because of whatever reason. To me, that's sort of, I think that's a matter of immense privilege to say, well, at least I can consider myself the adult in the room. Meanwhile, millions of women don't have access to birth control pills. Right? I just think that the scope of the things to be achieved is totally disproportionate to being quote unquote an adult in the room. I think the second point on that's worth saying is after World War II, there were a lot of philosophers that had a lot to say about totalitarianism, and one of those was Hannah Arendt. And what she said is that the extremely right-wing elements in the 20s and 30s depended on liberals to be the adults in the room, that they depended on liberals respecting open discourse and open government and letting them into the public square. And as soon as those totalitarians came into power, they shut the doors behind them. And they depended on knowing that the left would never strike out at them in violence, whereas they would be happy to strike out at the left in violence. And I don't think that the Republicans are Nazis, but I think that a lot of the Republican political strategy depends on Democrats being the adults in the room. And I don't think the Democrats should let themselves be taken advantage of like that.
I think my problem there is that how do we get back to a normal system if someone doesn't make that sort of course correction, right?
We don't have a normal system regardless, right? Like the Democrats could be adults or the Democrats could not be adults, but it takes two parties to have a normal system, and we don't have a normal system no matter what the Democrats do.
I'm not even sure I agree with you that the Republicans paid no political price for their intransigence, but let's just say that that's the case, and let's just say that Democrats will pay no price for their intransigence and their obstructionism, right?
What political price did they pay?
I think they lost seats. They lost seats in the Senate. They lost seats in the House. And honestly, if not for 120,000 people, waking up a certain way, they would have lost the White House. So I think they did. I think they did pay a political price.
Think about the state they were in January of 2009 when Mitch McConnell held a meeting with Republicans and said, you know what, the way forward is obstructionist. So in 2009, when they decided that no action of a black president would ever be legitimate, they had a minority in the House and a minority in the Senate, and they had just followed up a huge crushing defeat in the Electoral College of the Republican successor to a catastrophically unpopular president. And if you look at the state of the party in 2009, when Democrats hold, 30-something governorships or whatever it is, and you look at the state of the party now, it's hard to say that the last 8 years have been unkind to Republicans.
So I guess the bigger point that I'm making, though, is that is it possible for the Democrats to make hay out of their lack of obstructionism, right? Is it possible for them to say, we are not going to be obstructionist and you should respect us for that reason? Or do you think that that's too much to ask?
No. There's no gain in playing along nicely like it's still the 1960s and it's still the era of great moderation. There's no point.
I mean...
It's not.
Well, I think
this is normal now.
If that's the case, then it's sort of like you kind of have an arms race, right? And what you're saying is, what you're saying is sort of like, instead of doing any type of, unilateral disarmament to show your sort of good faith, you should just increase your armament.
Like, President Obama had all sorts of tools that he didn't deploy, right? It took Democrats until the second term of the Obama presidency to deploy the nuclear option. And it took Obama until 2014, 2015 to really start using executive orders to the fullest extent. And so I think the Democrats were sort of unilaterally disarmed for a period of 5 or 6 years before they realized that this is a new normal and there's no point. So for the record, Tom's latency is 31 milliseconds and Ruch's latency is 968 milliseconds. Rich, maybe you should go record at your neighbor's house.
Yeah, or at least get closer.
All right. Well, I think actually this is a good place to stop. I think that our democracy is a shambles. Gorsuch is sort of a corporatist shill, and we ought not to have a judiciary anymore. Is that sort of resolved? Is that sort of the list of everything we know about the American heartland?
I think that's pretty much it.